My name is Richard Akin. I'm a shareholder at Henderson, Franklin, Starnes & Holt in Fort Myers, Florida. One of the areas that I practice primarily in is the area of school law, representing school boards around the state. I've been doing that for at least 10 years throughout part of my practice. I'm here today to talk to you about the First Amendment in school issues. We're going to talk a little bit about how the First Amendment relates to and regulates school speech in the electronic age with things like Twitter, Instagram, and we'll just hop right into it. Typically, I get a lot of questions throughout this presentation, so I know that won't be the case today, but I'll try as I go through to address some of the questions that I typically get, some of the frequent flyers, if you will. So one of the first things I want to do as we start this presentation is I want to talk about what is the First Amendment. I think it's a good starting place. And I know that everyone has heard of the First Amendment, and most of us have probably read it, but I do think it's a good reminder to see exactly what it is, because there's a lot in there. There's more in there, perhaps, than everyone realizes, especially when we think about it on a daily basis. So the First Amendment provides that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or of the right of the people peaceably to assemble and to petition the government for redress of grievances. So as I said a minute ago, there's quite a bit there in the First Amendment. Today, we're not going to talk about all of that, but it's good to know as you look back through it that there's quite a bit there, and that it does not just address freedom of speech as you might commonly think, or as a lot of people commonly think when they hear it referenced. And that it's kind of important is, to whom does the First Amendment apply? And this is an important question. Obviously, it applies to Congress. It says it right there in the very first line. It applies to Congress. Congress shall make no law, right? So that's not much is clear. We also know that it's been well settled it applies to the federal government. But we now know, and this has been well settled for quite a while, that the First Amendment applies to state and local governments as well. And it applies through something that's called the incorporation doctrine, and that's a doctrine basically based upon the due process clause of the 14th Amendment. So all of the first 10 amendments, which is known as the Bill of Rights, including the First Amendment, apply to federal, or to both the federal government as well as the state and the local governments through the incorporation doctrine. What's also important to know is that the First Amendment does not apply to businesses or private individuals. And when I mean that, or when I say that, what I ultimately mean is that it doesn't prohibit a private individual or a business from regulating someone's speech. All right, and so how does that really play into what we're talking about here today? I know that typically when I give this presentation, I've got teachers from both public schools as well as private schools, and certainly the First Amendment applies to all public schools. Whether or not it applies to a private school, the answer is going to be typically no. It's not going to apply to a private school. The reason for that is simply that a private school is not a governmental entity. And so because the First Amendment only applies to restrict the conduct of governmental entities, it applies to public schools. That said, even if you're a private school teacher, I hope that you'll find this interesting. There is a lot of good stuff in here. So let's talk about now, we mentioned a minute ago what the First Amendment is, and we walked through some of the things that it covers. And then, as I said, there's a lot in there. There's several protections within the First Amendment that apply commonly in school settings. So the two that we think of commonly are religion and free speech. And the religion part of the First Amendment, there's what's called the Establishment Clause as well as the Free Exercise Clause. And just briefly, the Establishment Clause basically is that government shall make no law regarding the establishment of religion. And what that means is there can't really be an official religion of the United States of America. That comes from when the founding fathers came over to the United States. Many of them were coming to escape religious persecution or to escape places where, more specifically, there was an official church of the state, Church of England, something of that nature. And so they provided in our Constitution there is no official religion. There cannot be an established religion in the United States. But the second part of it is the Free Exercise Clause. Congress shall make no law respecting the free or inhibiting the free exercise of religion. And so that just means that you're free to exercise the religion that you so choose. We see a lot of cases in the school context that relate to religion in both the Establishment Clause context and the Free Exercise context, more in the Free Exercise context these days. I'm not going to really talk about that today, but I did at least want to explain it that comes up very commonly in the school settings. The second part of the First Amendment that really applies a lot in schools is really the right to freedom of speech. And so that's what I'm going to kind of turn my focus to as we go through the rest of my presentation here today. So as we talk about freedom of speech, one of the first things, I like to start with the building blocks here. What constitutes speech? And some of it's pretty easy, right? We know verbal speech, traditional speech, that's speech. We all know that that's pretty clear. a lot of times it's very obvious and people think of written things, written newspapers, something that you might write and post online, something like that. That's speech. But there are other more gray areas sometimes where we question, well, is that conduct speech? And the courts have found that expressive verbal conduct can constitute speech and can be protected, in fact is protected by the First Amendment under the right circumstances. So what is expressive verbal conduct? And the reason I want to mention this is because it really does come up quite a bit in the school setting. A lot of the cases that we've seen really are not traditional speech, but they're really more expressive verbal conduct. So expressive verbal conduct exists if the intent to convey a particularized message is present and if the likelihood is great that the message would be understood by those who viewed it. So it's really kind of a two-part test. And I've got, it looks like 4 cases that I've listed here that really talk about expressive verbal conduct and identify what expressive verbal conduct can be. There's the Akin case from 1990, that's burning a flag. The court found that burning a flag is certainly expressive verbal conduct that can be, under the right circumstances, protected by the First Amendment. The Tinker case, which I'm sure all of you are very familiar with and we'll talk about a little bit more in detail. The Tinker versus Des Moines case, that's wearing black armbands, and that is in the school setting. Obviously, wearing a black armband, the court found that was expressive verbal conduct because there was an intent to convey a message, and it was likely that the message would be understood. We've also got the Spence case. That's a Supreme Court case from 1974. Defacing a flag, similar to burning a flag, that's expressive verbal conduct. And Brown versus State of Louisiana, that's another Supreme Court case from the late 1960s, and it's a participation in a silent sit-in. Again, the court said that is expressive verbal conduct because there's an intent to convey a message. Everybody knew what the sit-in was about, and it was likely to be understood by those who viewed it. So keep that in mind when you're thinking about speech in the school context. It doesn't have to be traditional speech, verbal speech, a student standing up in an auditorium and giving a speech, or a school play or a school newspaper. It can be something a little different. It can be a message on an armband, a message on a shirt, a message on a face mask these days as we live in different times. And so it can be expressive verbal conduct as well. So turning to the next slide, one of the things that we talk about, and I mentioned right as I started off, is that a lot of the speech that we see in the school context these days, and a lot of the issues specifically that are faced by schools and by teachers, is electronic speech. How do you deal with it? Is it protected? What do you do about it? And so honestly, that's a lot about what I'm going to try to talk about here today. A lot of the cases don't necessarily apply specifically to electronic speech, but as we see, a lot of them are starting to kind of get into those areas. And so what we have to do is look at not only the older cases, but some of the newer cases and try to parse through them and decide, well, how exactly does this apply to electronic speech, especially when it may not occur at school. So we know that electronic speech is in fact protected by the First Amendment. It's speech, just the same as any other speech. Commonly, we think of these things as text, Facebook, Instagram, Snapchat, Twitter, all that kind of stuff. Blog posts, YouTube posts, all of these things are electronic speech. They all have protection under the First Amendment under the right circumstances. And I do want to state something, because this has come up a lot recently. When I talk about what is protected speech, and we also talk about the ability to regulate speech, right? So the First Amendment, again, I mentioned earlier, doesn't apply to private institutions. So many of these platforms that host speech, like, for example, Facebook and Twitter, they're not the government. And so they are not bound by the First Amendment. They can, in fact, regulate what people say on there, and many times do. They have terms of use, and you can't post certain types of messages or they'll get deleted. And so I want to make it clear there that the First Amendment doesn't, at this juncture, it doesn't in any way regulate those platforms' ability to regulate the speech. But when speech is made on those platforms, it certainly is speech that can be protected under the First Amendment to the extent a public school is trying to regulate that speech. So now that we've talked a little bit about electronic speech and kind of covered basically the mediums that it can take, I want to turn a little bit and I want to start to talk about generally when schools can intervene to regulate speech, because that's a lot of what we want to cover here today. So first, it depends on whether the speech is part of a school-sponsored activity or event. That's kind of the first thing that we want to look at. Is the speech actually part of is it a speech that a student's giving at school? Is it a speech that's part of an extracurricular activity? Is it at school just to begin with, or is it occurring away from school? Examples that we see of school-sponsored activities, I've got some things up here. These are just 3 that I could think of from case law that I've seen: school newspapers, plays, public speeches at school events, common sense types of things. The distinction that I want to try to draw here is that speech by a student simply while attending school does not constitute a school-sponsored activity, and it's given greater protection. And when I say that, there's nothing that's really bright line in the case law that says, hey, while a kid's at school, they're going to get greater protection if it's not a school-sponsored activity. But we really find when we look at the case law that there is a distinction in the way that those two types of speech is treated or are treated. So what I mean by that is if a student is walking down the hallway at school and talking to his or her friend and they say something, that speech is not going to be able to be regulated quite in the same manner as maybe what a student is doing in the school newspaper or during a play or at a speech sponsored at maybe in an auditorium as part of an SGA event or something like that. It does not mean at all that the student can't, or that the school can't regulate the speech and can't punish for improper speech. And one of the things that I always like to bring up as I'm going through this and beginning to talk about this, because I get these questions a lot, is, well, what if students are using profanity? And we're going to talk about the substantial disruption test in a minute. And I can say this, look, certainly there's nothing that prevents schools from disciplining students for improper behavior at school, okay? And to the extent they're using profanity, and profanity is really not protected speech in the first instance, at least in most circumstances, the bottom line is the school can do those types of things. The distinction I'm drawing here is that you'll see as we go through the case law, the school has a lot more latitude when it's a school-sponsored event and school-sponsored speech to regulate that speech. And they don't really necessarily have to show a substantial disruption quite to the same level that they would if it's just speech of a student while at school. The next slide that we have really asks the question, is this school speech? All right, and we talk about, and we're looking at a couple of different tests that have evolved over the years to try to determine that. And the first one, which we see is a Fourth Circuit test, is there a sufficient nexus between the speech and the school? So nexus, relationship, is it sufficient? And then we see this other test that I've got on the slide here, which is from the Eighth Circuit, and they say whether it was reasonably foreseeable that the speech would reach the school. They're similar. They're not all that different, but at the same time, what they're really focusing on is the relationship between the speech and the school, and whether there's a connected or enough of a connection there. And we'll see that a lot of the cases that we're going to talk about today, one of the issues is there's speech that's occurring off campus entirely. It's not happening in the school. If it's happening in the school and it's students misbehaving or violating codes of conduct while they're at school, the ability to regulate and punish for that is much greater by the school. The problem becomes when they're doing something away from school, when they're at home or they're at a restaurant or they're at a friend's house and they do something, and the question is then, well, hey, can the school regulate this because we don't like this conduct? And we'll walk through sort of how the courts have treated those different scenarios. Here I'm citing this JC versus Beverly Hills case, and we're going to talk a little bit more about that case in a few minutes. But I like to put this quote on the screen every time I do this presentation because I think it's interesting. It says, public schools have an affirmative obligation to instill in students the fundamental values of habits and manners of civility essential to a democratic society and to teach students the boundaries of socially appropriate behavior. The reason I like this is because I think it's an interesting question, and it sort of sets the stage for everything that we're talking about in many of these cases. But I think there's a struggle that goes on not only in the courts but in everyday schools that many teachers have to deal with, which is, what are the fundamental values and habits and manners of civility essential to a democratic society? And what is socially appropriate behavior? The bottom line is that those things are moving targets. They're not going to stay the same all the time. They're not static. And so because of that, because what is a socially appropriate behavior, what the fundamental values of society are is constantly changing, I think what you're going to see is if you read maybe cases from the 1960s, you get a little bit different flavor than you do if you read a case from 2019 or 2020. And so that's important. But it's also important to remember that some of these questions are hard questions to answer. Socially appropriate behavior. It's been 20 or 25 years since I was in high school, but I think about what socially appropriate behavior might have been back then, and I certainly think that many things that are socially appropriate today would not have been back then. And that's not to say they're good or bad, it's just that it's an evolving and ever-changing thing. Some of it probably is good and some of it is probably bad. There's probably some of each. And certainly things that were socially appropriate in the 1950s, many of the things today that are socially appropriate wouldn't have been back then, and vice versa. And so that sets the stage. That's why I like to look at that quote, because I think it sets the stage for some of the difficulties that are faced in trying to resolve many of these issues. So here on this next slide, I'm looking at non-school sponsored activity, and we try to identify what that is. But this is a quote from the Tinker case, which I think all of you have probably read. I'm confident that you've at least heard of it. But in the Tinker case, the U.S. Supreme Court back in 1969 said student expression may not be suppressed unless school officials reasonably conclude that it will materially and substantially disrupt the work and discipline of the school. So this is the substantial disruption test that I mentioned a little while ago. Bottom line is that if a school wants to regulate student speech that's non-school sponsored speech, okay, just activities of students at school, they've got to show that it's a material and substantial disruption to the ongoing operations of the school. And I have down here that courts have now altered this standard. The bottom line is that they haven't come out and explicitly said that they've altered this standard, but if you kind of read it, read the case law, you'll see that it's really not quite a material and substantial disruption. And this is something that I always get a lot of questions about, and I tried to address it a little bit earlier, but I get a lot of questions from teachers. All right, so you're telling me if two students are walking down the hallway, that's not school-sponsored activity, but it's at school, and they're talking about an inappropriate topic or they're using profanity, that I can't punish them. And I go, well, no, that's not what I'm telling you. What I'm telling you is that if you've got a school code of conduct, which I'm sure you do, that says they can't use profanity and they can't be minor, even if it's just on a little level disruptive, you can certainly discipline them for that. Really what this is talking about is a different kind of scenario where they're not using profanity, they're wearing an armband, obviously in the Tinker case, and it's not really disruptive. And the courts are saying, well, if it's not disruptive, we're not going to let you just step in and decide that you don't like the content of the speech. Turning to the next slide, I talk a little bit about the Tinker facts and non-school sponsored activity a little bit further. Again, Tinker, everybody knows it, but I'll just run through it really briefly. Students organized wearing black armbands because they wanted to protest the Vietnam War. The school tried to intervene and stop them from doing this. Ultimately, the United States Supreme Court said, no, you can't do that. First of all, it's expressive verbal conduct. We talked about that before. Therefore, it's speech that's protected by the First Amendment. And secondly, there is not a material and substantial disruption that has occurred on campus, and therefore you can't regulate it. The other thing that I want to point out that I think is important here, the court doesn't specifically talk about it, but it's political speech. It's speech that's made on a political subject. And you'll find anywhere in First Amendment jurisprudence that when you're regulating political speech, you get into a little bit more trouble pretty quickly. The courts disfavor that more than they do other types of speech. So ultimately, the Tinker facts, and the Tinker is where we start. It's the material and substantial disruption test, and that's the test we begin with. That's the test that's still valid today. Although the lower courts, the district courts, and the circuit courts of appeal have looked at how to apply that in an ever-changing environment, as we've kind of discussed a little bit already. And so we'll walk through some other cases that talk about how they apply that standard today. So the next case that I want to talk a little bit about is Hazelwood. And everybody probably, most of you I would assume, have heard of Hazelwood. It's a relatively famous case as well. And this is a United States Supreme Court case from 1988. And I've talked a little bit about school-sponsored activity, so this is where we're getting into now. Student staff members on a school newspaper. The Board of Education funds the paper in part. The article that the students had written to publish in the paper discussed 3 students that were at the school and their experience with pregnancy, and then there was another article that discussed the effect of divorce on students. There were fake names that were used, so they substituted the actual names of the students in order to remain or to keep their anonymity. But the school said, we don't think that this is appropriate and we want to remove it from the paper. In fact, they did remove it from the paper and they didn't print it. And so the students filed suit. They said, look, this is not appropriate. This is our speech, and we think that we should be able to publish it and it shouldn't be censored. And I've got on the next slide some quotes that I've taken out of Hazelwood. And the reason I pulled these quotes is that, again, I think they're interesting, and I think they sort of explain a little bit kind of what we see from the courts and the courts' thinking on exactly how they're trying to apply the First Amendment. And here on this first one on the top bullet point, they say, First Amendment rights of students in public schools are not automatically coextensive with the rights of adults in other settings and must be applied in light of the special characteristics of the school environment. So what is the court saying there? Well, what they're saying is, look, students don't get the same right as an adult walking around on the street. They are here to be educated, and because they're here to be educated, in the school to be educated, the school has the ability to regulate it a little bit. And this goes all the way back to that quote that we talked about earlier when we say, you know, what are the fundamental values of society and what are socially appropriate behaviors? And the school gets to make a call on some level about some of that. They get some leeway there. The second bullet point, and this really goes to the difference between school-sponsored speech and merely speech at school. It says the school need not tolerate student speech that is inconsistent with its basic educational mission, even though the government could not censor similar speech outside the school. So again, I think what they're saying here is this is a school newspaper. It's a medium in which the school has given students the right to and ability to publish certain things, but the school can kind of regulate, because it is in the school setting and because of the school's mission, they can regulate what goes in there. And they've made a determination that this isn't proper or appropriate, and therefore the Supreme Court backed them up. The next slide, where we're still talking about Hazelwood, talks about how educators are entitled to exercise greater control over school-sponsored student expression. And this is what I mentioned a minute ago, and that is, again, if it's school-sponsored expression, they get a lot more latitude than if it's just something that's happening at school. And ultimately, the court found here that a school could, in its capacity as a publisher of the paper, disassociate itself not only from speech that would substantially interfere with its work or impinge upon the rights of other students, but also from speech that was, for example, ungrammatical, poorly written, so on and so forth. So again, the court's kind of looking at this, and I think they're saying, well, this newspaper is an opportunity, it's part of the educational mission of the school, right? Nobody would dispute that the school could come in and say, well, look, this is poor grammar and we're going to edit what you've said. They can do that. And so by extension, they can go a little bit further and they can say, we don't believe that the topic of the article is an appropriate topic, and we're going to take it out altogether. So ultimately, again, I think it's important in this case, in the Hazelwood case, that we remember that it's school-sponsored speech. It's a newspaper that is put on by the school, that is written by the students, but that is ultimately still school-sponsored speech. The next case I want to talk a little bit about is the Bethel School District versus Frazier case. This is another Supreme Court case, also from the late 1980s. And one of the things I like to point out here is that when most of these cases, I always think it's kind of funny, most of these cases that we see involve high school students. It's never elementary school students. It's not very often middle school students. It's always the high school students who are getting in trouble and I won't say causing problems, but where there's always an issue, something's going on. The Bethel case is actually one of my favorites because this is one where a student gave a speech at an assembly nominating another for student government, and in his speech he used some graphic sexual metaphors, or at least that's what the case says. And if you're interested to see what exact sexual metaphors he used, you can always Google it. You can find the speech. But I always liked this case because when I was in high school, I actually had a classmate who was nominating another classmate for student government office and did something very similar. Got up and gave a speech in front of about 1,000 students, and in so doing used some sexual metaphors, innuendos in his speech. He actually, to my knowledge, did not get punished. I think it went right over the head of some of the administrators, and I think some of the other ones thought it was funny and just didn't think it was worth punishing him over. But this is the type of thing that happens, right? And on this slide, I've got some of the other facts, and I always like to lay out some facts and say, do we think these facts are material? Because when you read a case, you got to kind of determine it. So it was in front of approximately 600 other students, so it's at school. And prior to the speech, teachers warned him not to give the speech. I always like to ask, do we think that's an important fact? The bottom line is here, I don't think that's an important fact. I think it might be important to how much punishment he got if he knew ahead of time he wasn't supposed to do it. But I don't think that's really important. Ultimately, what's important is that it's at a school-sponsored event, student government event, it's in front of a bunch of other students, and that he's being given the platform by the school to give the speech. So he was suspended for 3 days. He was prevented from speaking further at school functions because the school decided that they didn't like and were not okay with the messages and the sexual metaphors that were in his speech. Ultimately, the Supreme Court upheld the school's ability to discipline him. They said that this is school-sponsored speech, that it created a disruption at this large-scale public gathering of students. And essentially, ultimately, I think because this is a school function, the school could discipline Frazier for the conduct, and they had greater latitude. Notably absent from this case is any ultimate facts that show, hey, there was a real substantial disruption. Students were just, rioting in the hallways. I'm sure they weren't. I'm sure they were all laughing about it. It's not the type of substantial disruption that you might see in later cases that we'll talk about the courts say is needed. However, I think the determining fact here, again, is this is school-sponsored speech. He's given the platform, he's up there, and ultimately, because he's given that platform, the school has greater latitude to tell him what he can and can't say. The next case I want to talk a little bit about is TV versus Smith-Glenn. This is a 2011 case from the Northern District of Indiana. So one of the things that's always important to keep in mind is when we look at a Supreme Court case, which is the highest court in the land, versus maybe a district court case. And sometimes in the district court cases or even the circuit court cases, which are and a circuit court of appeals is between the district courts, which you would think of as a trial court, and the Supreme Court, that you may see a little bit of difference in how they apply this. But we usually, in some of the district court cases, they're interesting in my mind because you get a little bit more in the way of facts sometimes. You get a little bit more of the district court judge discussing the intimate facts of the case. In this case, again, we've got a girls' 10th grade volleyball team. Again, high schoolers, like I said, are frequent flyers in these cases. They're always causing trouble. Girls' 10th grade volleyball team, there were some sexually suggestive pictures that were taken at a party. It was an off-campus party, slumber party, and they got posted on Facebook and MySpace. And I guess MySpace was still around in 2011. And photos in this case didn't show any indication of a connection to the school. They were just photos posted by members of the team. The school claimed that the photos were causing a disruption in their athletic teams, and they tried to discipline the conduct. And I always like to point out here, it mentions in the facts that the photos don't show any indication of a connection to the school, and that's one of those facts that I'm going to ask you in a minute. What do you think? Is that an important fact or not? But after this happened, the school makes a determination that the photographs were inappropriate, that they posing for them and posting them on the internet, the students were basically discrediting the school. They were suspended from extracurricular activities, and they weren't allowed to do any other co-curricular activities for a year. So what's the outcome here, right? They're off campus, they're not on campus. It's clearly not school-sponsored activity, but the school's claiming here, well, it's coming back to the school and it's creating a disruption. What does the court ultimately hold? They said, first of all, pictures are expressive verbal conduct, and therefore they're protected speech, all right? They were intended to convey a particularized message, even if it was a sexual message that people might not have liked, and it was likely that whoever saw them would understand that message. So they're protected. But the court also held that the pictures in their posting online did not constitute a substantial disruption, and that takes us all the way back to Tinker. There is no substantial disruption that was found by the court in this. And I like this last quote here on this slide because, again, I think it's one that I refer to a lot of times when I'm asked a question by a client. Petty disagreements among players on a team or participants in clubs, for that matter, is utterly routine. This type of unremarkable dissension does not establish disruption with the work or discipline of the team or the school, much less disruption that is substantial or material. All right, so the court here is referring back to the Tinker test, a material and substantial disruption. And I just love that line about it being utterly routine. Again, these are high school students. They're going to do these types of things. It's utterly routine. If they had done it on school grounds and they violated the conduct code while they were there, you probably could have punished them. But this is off campus, and the school hasn't been able to show that there was a material and substantial disruption on campus as a result of the posting of the pictures, simply because it's conduct that they don't like and they don't agree with. That's not enough. You can't punish them for it. It's protected speech. And so now I want to go back to that question of, well, let's say that instead of there not being any indication in the photographs of a relationship between the schools. So in other words, they're not wearing a sweatshirt that says, Fort Myers High School or whatever on it. What if they had been wearing a sweatshirt that had the school logo or the school name on it, something of that nature? I guess in this case it would be Smith Glen High School. Well, I don't think that would have made a difference. The court doesn't spend a lot of time discussing it. It is mentioned in passing. But the bottom line is, if the question that we're asking is this a material and substantial disruption on campus, whether they're wearing a school sweatshirt or a school shirt really doesn't matter. Now, there might be a trademark issue there potentially, okay? However, ultimately, if we go back, and then I've heard some try to argue, well, if they were wearing a school sweatshirt, maybe it would be viewed as school-sponsored speech because they're doing it while in a school-logoed sweatshirt. The problem there is that it's really hard to argue that anybody, let's say, I went to Florida State, I got my undergraduate, my law degree there. Let's say that I put on a Florida State shirt and I go around and I do something foolish or crazy. I don't necessarily believe that people are going to believe that that Florida State or whatever school shirt I'm wearing is promoting that behavior or I'm promoting their agenda. Now, I might get some other people from rival schools making fun of me and using it to say, haha, look at this guy. But the bottom line is that just by wearing a shirt, a logo, something like that, it doesn't make it school sponsored. So I don't think that fact would have mattered. We don't really get a lot of discussion on that. But I think it's interesting to discuss from time to time because it's a question that comes up. Now, turning to the next case, the JC versus Beverly Hills case. This is a California case, another district court case from 2010. Again, we have high school students. I always like to joke. High school students, always the problem. After school was out for the day, several friends meet at a restaurant. JC records a video of two others saying derogatory, sexual, and defamatory things about another classmate. JC is encouraging this conduct, and then she turns around and posts the video on YouTube from her home computer. All right, so none of this happens at school. All right, it's all happening at a restaurant off campus. The video itself is not posted from school, it's posted from her home computer. So we don't have conduct on campus. It's estimated that there are at least 15 students from the school that see the video, at least 15. Another parent complained. I think it was the parent of the student about whom the video had been made. They were very unhappy and they complained to the school. The student about whom the video was made refused to go to class the day after discovering the video. And the students seen in the video were ultimately sent home from school and they were suspended for a couple of days. And so the question here is going to be, is this enough for the school to punish? Can they regulate this speech? And again, it's speech, very clearly. So the question, and if we look at this next slide, I've got some block quotes, or they're not quotes, but that I pulled out of this case in order to specifically talk about what is the court looking at, what are they discussing. And the factor that was really relevant here to the substantial disruption inquiry is whether school administrators are pulled away from their ordinary tasks to respond to or mitigate the effects of student speech. Whether the school's decision to discipline is based on evidence or facts indicating a foreseeable risk of disruption rather than undifferentiated fears or mere disapproval of the speech. And again, this goes back to that quote that I showed you from the Indiana case, which talks about utterly routine. Again, it's routine for high school students to behave badly. That's what they do. That's what the court's saying here. And so the court's saying that there has to be something more than this undifferentiated fear, this could result in something bad, and what kind of a bad example does this set, and disapproval of the speech. That's not enough. Basically, the court's going back to Tinker, and they're saying there has to be a material and substantial disruption, and it has to occur on campus. Here, the court held there was no substantial disruption. Again, ordinary personal conflicts among teenagers, utterly routine, the type of stuff they do all the time. And here, I want to point out, I think this is a good place to do it, that just because the courts are saying here that if there's something that happens off campus that doesn't result in a material and substantial disruption on campus, the school can't punish or can't necessarily intervene. That doesn't mean that there's nothing that the school administrators or teachers can do. And when I say that, one of the things I always like to mention is, look, if you know that something is going on and that there's an issue, can you try to call the students in and talk to them, try to mediate a resolution, talk to their parents? Hopefully their parents will get involved and do something. The First Amendment does not prohibit those types of activities. It doesn't prevent you from having discussions. It doesn't prevent you from mentioning it to their parents, to trying to get somewhere in that way. You just can't punish them. You can't regulate the speech. You can't basically punish them at school for what they did off campus in these types of facts unless there's a material and substantial disruption. And so I like to point that out. I know that's not something that's always terribly satisfactory to school teachers who want to know. They say, well, look, this behavior was inappropriate. They made fun of this other person and they made them, they bullied them off campus essentially. That's true in some cases, but the First Amendment does give protections. And so there are things you can do, and I know it's not satisfactory to say, well, you can't bring the hammer down on them, but at least that's a distinction that I wanted to draw there. All right, so with that in mind, the next case that we're going to talk a little bit about is the Levine versus Blaine County School District, and that's a Ninth Circuit case from 2001. So Ninth Circuit is a district, or not a district, it's a Circuit Court of Appeals in California, and it's basically West Coast. It makes up several of the states out there. Here we have an 11th grade student, once again, high school student, to no one's surprise. But these facts are going to be a little bit different. So he writes a poem at his house. He doesn't write it at school. He writes a poem at home about killing his classmates. He brings the poem to school, and he shows his English teacher, who in turn decides to show the principal. She reads it, and she's alarmed by it. We also know from the facts of this case that the student had a history of mental problems. And the principal makes a decision that he's going to emergency expel the student due to a threat of danger to students and others. All right, so there's a poem that the student's written. It's about killing classmates, and the principal says, I'm really worried about this. I'm going to emergency expel the student. So the court is going to view this, we're going to see a little bit different. Here they talk about the fact that the school has a duty to protect students and to prevent violence. Schools are given deference with regard to decisions affecting student safety, and the court really talks about that in this case. Here they say the student's First Amendment rights were not violated because there were factors that could reasonably have led the school to forecast a substantial disruption on campus. All right, and so remember, we're always going back. The opinions are always trying to tie their decision to the Tinker standard, which is still the law, right? So material and substantial disruption. And So what the Ninth Circuit says here is, well, look, there are facts. There's a student who you know has a history of mental illness, and there is a poem that was published that talks about killing classmates. And so there's a reason to believe that there's going to be a material and substantial disruption that involves the safety of students, and therefore you can intervene and take action. And one of the things I always say, or as I've said going through some of these slides, what if we take this fact and we remove it? So what if the student didn't have a history of mental illness? I don't think that really would have mattered. I think it bolstered the case for taking the action that they took, but I probably don't think that matters, especially as we'll see there's going to be some other cases that are along the same lines about student safety. But I do think it's important to point out in the Levine case that they're playing loosey-goosey a little bit in my mind anyway with the substantial disruption test. And when I say that, there has not been a substantial disruption, but they're saying there could be a substantial disruption. And so what they're ultimately saying here is, yeah, we're going to find it to be something that it's almost, to me, in my mind, the way they treat it is almost in its separate category because it involves student safety. And so they're saying there could be a substantial disruption, it's a credible threat, and you have the right as a principal and as a school to take it seriously. And so that's important, and we're going to see that carried on throughout some other cases. And the next case on that point is the Bell versus Itawamba County School Board, and I hope I pronounced that right, I'm just not sure. But ultimately, this is a Fifth Circuit case in 2015, a little bit more recent. Again, it's a high school student. He wrote a rap song that made references to shooting his teacher and his coach. He recorded the song away from school and he posted it on Facebook. School obviously found out, to no one's surprise, and they decided to suspend him for threats to teachers and forced him to attend an alternative school. So the question that's raised here, and the court discusses it, is does the Tinker standard apply for conduct away from school? Obviously, when Tinker was decided, the world was a much different place in the 1960s than it is in 2020 or in 2015 when this case was decided. You didn't have the internet, you didn't have cell phones, all the things that we have now, they're part of common everyday life. And the court's recognizing in this decision, they're saying that these technologies present new and evolving challenges for school administrators. And the boundaries that we previously thought of before about whether it's happening at school or it's happening away from school really aren't the same. We've got to rethink how we're going to apply all this. And they said here, school administrators must be vigilant and take seriously any statements by students resembling threats of violence as well as harassment and intimidation posted online and made away from campus. So what they're saying here, what they're recognizing is, hey, look, if you know that there's a credible threat or maybe not even a credible threat, a threat of violence, you've got to take it seriously. You've got to look into it and you've got to take action. And so ultimately they said, in this case, the school could punish. They could take action, even though this happened away from school. They didn't even really talk a whole lot about the substantial disruption, but they said in this case, under these facts, similar to what we saw in Levine, the school could punish. They could take action. School or student safety is at issue, and so therefore we're going to let you do it. And they say here in this case, and I think it's very important, our holding concerns the paramount need for school officials to be able to react quickly and efficiently to protect students and faculty from threats, intimidation, and harassment intentionally directed at the school community. And they made very clear in this case that they weren't creating a new rule, that they were just making this holding based on these facts. So these facts they felt gave them a need or created a need for them to go ahead and make that finding without creating a new rule. So again, as I get away from the threats of violence type of cases, just remember that almost in any case where there's been a threat of violence that's come in front of the court, even if it was a video posted away from school or a poem that was written away from school, schools have said if the school becomes aware of it, they have a right to act. They can write. They can act in order to protect the safety of students and teachers. So we're gonna turn the page a little bit. And we're going to talk about a few other interesting circumstances that may not apply directly to high schools and things of that nature, but I do think they're interesting. The next case is Keefe versus Adams, and this is 8th Circuit from 2016. And this is a nursing student, so this is at the college level. It's a public college. Nursing student made Facebook posts off campus that were derogatory about classmates. And the college expelled him. They said, this is not appropriate, we're expelling you. The court here decided that the school was able to punish the behavior. The college was. And so why? Why are they able to do this? It's done off campus. We've seen a whole bunch of cases that say they're not able to punish students for posts speech that are made totally off campus that don't actually result in a material substantial disruption or threatened material substantial disruption on campus. And here the court gets there a little bit different way, and the college argued it a little bit different way. What they said was that professional and ethical standards were part of the curriculum and that they were part of the graduation requirements. And that because of the nature of this post, the student was deemed to have violated those professional and ethical standards, and therefore they could say, well, because he's violated the ethical standards, we're going to expel him from the school and we're going to find that he has not met the curriculum and graduation requirements, or raises significant questions about whether he ever could. And the bottom line here, keep in mind that the court's looking at these standards and they're saying that ethical standards for a field are a permissible part of academic standards. So you're going to see that as you get into colleges and professional schools where there are additional ethical requirements to get the degree. You know, if you're in law school, you have to have, they ask you a lot of questions about your criminal background and your background about anything that might have to do with misrepresentations previously made, because that might prevent you from getting admitted to the bar at a later date. So those are professional and ethical standards that are very important in that context, and they're deemed to be part of the curriculum. And the same is true in this case for a nursing student. I'm sure it would apply to a number of other settings as well. And again, the court kind of comes back here and they say, we're not really prohibiting speech. Instead, what we're doing is imposing adverse, that the college is imposing adverse consequences for speaking at the wrong place and the wrong time. And we're going to go ahead and say that they have the right to do that in this context. And what's interesting here is adverse consequences for wrong place, wrong time. And all right, so now we're going to turn to another case. It's Shin versus Albany Unified School District. And again, we have high school students here, so we're going back to high school students at least one more time. And they created an Instagram account with racist and derogatory messages about other students and teachers. They invited other classmates to follow it. And this resulted in what was referred to in the case as a cascade of disruptive events at school. Counselors were called, police were called, things had to be resolved. The school expelled those who posted made the post and created the account, and suspended those who had merely followed the account. The court upheld the punishment for those who had made the posts and created the account, but they overturned the punishment for those who had only followed the account. And what I thought was interesting out of this case is that they say geographic tests are still a relevant factor, but strict tests of locality are not compatible with the online methods of communication in our digital age. So the court there is really recognizing one of the things that I think many teachers today struggle with, which is we've got a bunch of tests and rules that were really kind of built and made in a time frame where you didn't have a lot of the electronic means of communication. So now you got to apply them today. And so the court's struggling to apply the Tinker test here because it didn't happen at school. It happened away from school. It was all done away from school. And they're talking about a material and substantial disruption. And you'll note that on that first slide about the Shin case, I say that there was a cascade of disruptive events. The court kind of skips over it a little bit. They talk a little bit about what happened. But ultimately what they're saying here is that there was enough disruption on campus, even though the conduct happened off campus. It was about students at the school, and it resulted in enough material and substantial disruption here on campus. And because of the racist nature of it, the school was able to actually punish students. And when I get to this case, I think it's a good idea to point out and to talk a little bit about, I know that bullying is a major issue that comes up in many schools today. And most of the questions, or many of the questions that I get in this presentation, have to do with that very issue. Hey, I know, what if teachers know or are aware of Instagram posts, tweets, Facebook posts, something else, text messages, where a group of students or a single student is picking on other students. It's not happening at school, and I can't really point to a substantial disruption, but I know that it's not appropriate, and given the Jeffrey Johnson Stand Up for Students Act, how do we respond? One of the things that I like to say here is, well, let's remember what we're talking about and what we're not. And what we're talking about is, can you punish those students strictly for what they've done off campus? And my caution is always there, be very careful. It's tough. There are very, very few cases where the courts have found that when conduct occurred and post-speech occurred completely off campus, not on campus at all, that it could be regulated and punished by the school. Very, very few cases that hold that. However, there are, as my grandma used to say, there's more than one way to skin a cat. And think about it like this. If you're aware of the fact that this is going on off campus and you know that these students are having trouble, again, it doesn't prevent you from calling their parents in, trying to have the conversation, and maybe that doesn't work, and I understand that it becomes a lot more complicated in many of those types of scenarios. But
The other thing is, if it's going on off campus, there's probably something going on campus too. Try to catch them doing it on campus. And you can punish them for that. If they're making fun of bullying, harassing another student on campus, and you've got actual catching them do it, and you can prove it, punish them for that. There's other ways to kind of do it. If there is actually a substantial disruption on campus that's resulting from the off-campus speech, then you can punish it. The other thing that you'll see is that I think many schools have policies where students are obviously allowed by statute to have their phones in school, but they're not supposed to have them out while you're teaching, things like that. They're not supposed to be using them at certain times. And so you might be able to catch them doing things, making the posts at school, doing things like that, posting them even if it's on a study break or something like that. If it violates a code of conduct at school and it's something that's inappropriate, like bullying or harassing another student, you can certainly take action for that. So I guess what I'm really saying there is that sometimes, given the rights that public school students have to freedom of speech, you have to be a little bit more resourceful. But I will also say that just because you can't punish them for something that's happening off campus, if you know that it's happening, if you know that there's something going on, you do have a duty under what would sort of be the negligence laws of the state of Florida and the Jeffrey Johnson Stand Up for Students Act. You may have a duty in those circumstances to take some action and to try and at least be a little bit more vigilant at school as to what's going on. You have an idea this is happening. What's going on? Try to talk to the students, try to resolve it, try to take some sort of action. So keep that in mind. I know it's a complicated and a difficult scenario for teachers and administrators to deal with, but that is how it is. So next I'm going to turn to the Yeeson versus University of Kansas. This is a district court case from Kansas in 2015. And this is an engineering student who tweeted a series of derogatory comments about his ex. He called her a psycho, he mocked her appearance, and there was a no contact order with his ex that had previously been entered. The university expelled him when they found out that he had made these tweets. There was a provision in the code of conduct at the university that allowed the university to punish students for violations that occurred while on campus. So what they were trying to say was, well, they tried to tie it and say, well, the tweets might have been made on campus, and if he made the tweets and they were derogatory and harassing comments, and even if he typed them on a third-party application while he was on campus, that could have been a violation. And I sort of alluded to this a minute ago. But the bottom line here was the court said there's no evidence that the tweets occurred while on campus, and they said that the school couldn't punish here. That's the ultimate outcome. No basis to punish because it's speech that, as far as we know, is occurring entirely off campus. There's no indication that it's causing a substantial and material disruption on campus, and therefore you can't punish it. And what's interesting here, because we talked about the nursing case a little while ago about the code of ethics, there is really no discussion here about that. And I might be interested to know if they had made that argument, whether it would have carried the day here. But I don't really see much of a discussion in this case about that. So it's interesting, and I really think I wanted that case in here because it highlights the point that if someone makes a tweet that's a derogatory tweet and that's all it does, talking bad about someone, and it's done away from campus, even though it might be a bad thing, there's really very limited ability for the school to punish the student once they get back to campus. It has to be conduct that occurs on campus. That's within the purview and the jurisdiction, if you will, of the school, is what happens on campus. There's a few other examples that I want to run through here, and these are just a list of cases that I think are interesting, probably not worth spending a ton of time on, but interesting examples nonetheless. The JS case, JS versus Blue Mountain School District. This is a Third Circuit case from 2011. This is 8th grade students, so they're almost high schoolers. And they created a fake online profile. They were degrading the principal from their home computer. The school couldn't punish. Again, I think this is, falls into that utterly routine stuff. Okay, so 8th grade students don't like their principal, and they're saying bad, not nice things about him. Sorry, that's kind of what the court said. They said the principal gets some thicker skin. The Morse versus Frederick case, which is an interesting case, and I'm sure that many of you have actually probably read that case or taught that case. And that's a Supreme Court case from 2001. And this is where students unveiled a sign stating "Bong hits for Jesus" during a school-sponsored event. And what's kind of interesting about this case is that I believe that the banner was unveiled during the Olympic torch relay. This case came out of Alaska, and the Olympic torch relay was coming through the town here, and the principal had allowed the students to get out of class for the day in order to go watch the Olympic torch relay come through town. And when that happened, some of the students actually unveiled this sign that said "Bong hits for Jesus," and the principal didn't like it, so the principal decided to punish the students. And the court held that it was a school-sponsored event because they had been let out of class specifically to see the event. So in other words, if you change the facts around a little bit and school had not been in on the day that the Olympic torch relay was coming in, and the principal hadn't let them out specifically to go see it, instead they're just on their own time doing it, and a student had done that, unveiled that sign, the school probably can't punish. In fact, I feel pretty confident that the school wouldn't have been able to punish. The fact that that was a school-sponsored event was important. It was within the purview, and essentially what I think the court's saying there is, if the students were to go out in the parking lot at school and unveil a banner that said "Bong hits for Jesus," or if they were to do it in the lunchroom, you could punish them. Because this is just like a school field trip, it's during the school day, it's part of the school curriculum, you can punish them for doing it. So I think that was that's a very important part of that holding, and a very, very important fact. So the last case I've got on this slide is the Killen versus Franklin Regional School District case. And that's the Western District of Pennsylvania from 2001, so that's trial court, district court level. This is where a student composed a derogatory list about a school official off campus, and again, the school couldn't punish. So this is kind of like that JS case, which is up on higher on the slide again. Derogatory lists about school officials, the type of things that students sometimes do, unfortunately, but it's, again, pretty routine, utterly routine is the kind of thing that the court said about this. School can't punish it. Teachers need to get thicker skin. On the next slide, we've got a few more examples. The Burge versus Colton School District case, and this is Facebook posts about a teacher who gave the student a bad grade. Again, talking bad about the teacher because they got a bad grade, school can't punish it. Teacher may not like it, might not be very nice, but the school cannot punish. It doesn't meet any of the tests that would allow the school to actually take control of and punish the student for that conduct. The Weinar case, Weinar v. Douglas County School District. This is a Ninth Circuit case, and this was a website created to bully other students. It said that the school could punish. That's the ultimate outcome here. And I have in parentheses, be careful here. Be careful. This is a Ninth Circuit case, so it's not within the jurisdiction that where we sit here in Florida. It's not a Supreme Court case, and you got to remember the facts of the case. This one, I don't have a lot of facts here on the slide for you, but the bottom line is that the court's finding that there's enough of a disruption occurring on campus. There's some bullying going on. But I think you really need to be careful and generally think of, unless you can really show a material and substantial disruption on campus, similar to, like the Levine case held earlier, the Levine case held earlier, you got to be careful about regulating speech that's occurring strictly away from campus. The next slide I've got, I thought this is an interesting case just because it's a common question that comes up. I get it all the time. Bans of displays of Confederate flags are permissible based upon the rationale that certain symbols that have become associated with racial prejudice are so likely to provoke feelings of hatred and ill will in others that they are inappropriate in the school context. And importantly, this is an 11th Circuit case from 2003. The 11th Circuit is the circuit court. Florida is in the 11th Circuit. So Florida, Georgia, Alabama, all within the 11th Circuit. And it's important because this case, really what it's doing is it's seizing on something that is a question that I get all the time when it comes up. Well, hey, I got a student who's got they fly a Confederate flag in the back of their car or their truck or whatever. Can I punish them or make them take it down? And the answer is yeah. The 11th Circuit has held that you can. And the reason for that is really the racial prejudice element of that. But I also want to point out that's important here is that, look, this is talking about them displaying it at school or in the school context, all right? It's not talking about they're doing it on the weekend while they're away from school. Those two things are distinctive. Again, when students do something away from school, the ability to regulate it's a little bit more limited by the school. So, kind of wrapping up a little bit, let's talk a little bit about what we've learned, what we talked about, and when can schools intervene? Well, we know that they can intervene when speech causes a substantial disruption or there's a reasonable threat of substantial disruption. And this is only where we're talking about speech that's entitled to protection in the first instance, right? So some speech doesn't get any protection, and that is things like profanity. But when the speech causes a substantial disruption on campus or there's a reasonable threat of it, clearly schools can intervene. That really starts out with the Tinker test. We know from the holdings of many of the cases that we've looked at that there's broader latitude that's been given to schools with regard to school-sponsored events. All right, so if you're at a school-sponsored event, there's a lot broader latitude in school-sponsored activities such as a school newspaper, a school play, or a school speech. There's a lot of latitude given to schools there to regulate the speech because it's seen as promoting the school message or promoting the mission of the school. When they're doing that, when it's something that is promoting the mission of the school, part of the school's mission, part of the education itself, the school has great latitude to regulate, or a lot more latitude, I will say. We know that vulgar, obscene, or lewd speech has almost no protection. I mentioned that a minute ago. Profanity, things of that nature, just very little protection at all. And again, keep in mind, this is for speech that's occurring on campus. Threats of violence. And I think you can kind of think of some of these things, you can put them in separate buckets. And I really think those cases that we saw earlier that talk about threats of violence and that said, even when you've got a post that's occurring off campus, a post, a rap song, a video that's occurring off campus, they could punish it. And we did go through the substantial disruption discussion a little bit on those, but the bottom line is that where there's a threat of violence, it's been treated very differently by the courts. So now that we've talked about when schools generally can intervene, let's turn and talk about when generally schools cannot intervene. Generally, they cannot intervene when the conduct occurs off campus. All right, so we've seen in case after case where there's conduct that's occurring off campus, and we've seen that the courts have held school cannot intervene. The main exception that we've seen to that, as we discussed a minute ago, is a threat of violence. Where there's a threat of violence, school is generally able to intervene. They also cannot intervene where there's no substantial disruption that has been caused on campus. Again, that's the Tinker test, and I know you're probably tired of hearing about it from me, but the bottom line is that if the school can't demonstrate, whether it's on campus or off campus, that there's if they can't demonstrate a substantial disruption, it's going to be very difficult for the school to intervene and take action. And the final thing is, I say political speech here about Tinker. I just always like to highlight the fact to remember that when you have political speech, you need to have bells and alarms going off in your head if you want to regulate that speech. You really need to be thinking about, hey, this is political speech. Can I really regulate this? And what we'll see, and kind of in wrapping up, I do want to say that what you see is that a lot of schools have gone to something along the lines of basically saying no messages of any kind, right? So they're not regulating the content. They're just saying, hey, we're not going to let people put messages because we're afraid of issues if, somebody brings a message that, it might be a very basic message, but it might be something that would upset someone else. Then we get into the issues of political and this and that and the other, and we really don't want to have those problems. And so a lot of schools have gone into just simply saying we very content neutral restrictions, no content of any kind. But again, just be careful with political speech, because as we've seen, or as I think you've seen from this, and as you've probably seen from your own studies, that's where this all started with the Tinker case. So that concludes my presentation today on First Amendment and free speech issues in schools. I want to thank all of you for your time, and if you have any questions, I know that given the format you weren't able to ask me as many questions as you might normally, but if you have any questions, my contact information is there in the PowerPoint slide. Please feel free to give me a call or shoot me an email, and I will be happy to do my very best to answer your questions. And I wish everybody a happy 2021, safe and happy.